Assalamualaikum warahmatullahi wabarakatuh. Today we continue with our discussions, right? So the topic that we are going to discuss is the partnership law. So this topic is very important, right? And it will probably will come out in the final exam. So I hope that you can pay much attention on this topic. Right. Okay. As you know that in the sorry, this is wrong. That there are many business entities in Malaysia, right? But these entities are broadly divided into two. Most of them is divided into two, which are under the Business Registration of Business Act 1956, and also the Companies Act 2016. So Registration of Business Act 1956 is mainly focusing on those business entities which are called as under the domain of sole proprietorship, right? For example, partnership, eh? And yeah, there are two kind of businesses. One is partnership, another one is sole proprietorship. Okay. Whereas the Companies Act 2016, right, they are under the for those companies who are registered type of company, which is limited companies, unlimited companies, and public limited companies, right? So they are under the Companies Act. There are some other business entities, like LLP, we call it as Limited Liability Partnership. So this is under the Special Act, eh? Limited Liability Partnership Act, LLPA 2012. So in this topic, we are going to touch on the Partnership Act, eh, as well as the Limited Liability Partnership. Eh? So because we consider that the LLP also considered as a partnership, but they carry different liabilities. Okay, right. Right. Okay. So basically, in the when talking about partnership, when talking about partnership, the main law that governs the partnership is the Partnership Act, 1961, right? Revised 1974. So this is the main law, that govern the partnerships. Apart from that, we have also another provisions under Section 5 of Civil Law Act 1956. Obviously, Section 5 actually doesn't contain any law under the partnerships, but rather it give some guideline uh, for the legal practitioners to import or to apply the English law, the English law. So especially those laws which are related with the commercial matters, those law which are related to the commercial matters, we still apply the English law, provided that there is a lacuna, so the word here, so I just here, le, sorry, lacuna. So means is if there is a loophole on the law, right? Meaning to say, if there is no law regarding the partnership, we will apply the English law, right? So of course there is some condition on that. For example, like the application of the English law, in Peninsular Malaysia, for instance, they only apply for certain cut-off date, except in Penang, and Malacca. So except in Penang and Malacca, they are still receiving the English law until today. Okay, provided that there is a lacuna or loopholes on our law. Okay, so that is the principles under section 5. But first we have to refer to the partnership. We have to refer to this act first. Right. So okay. So what is the definition of the partnerships? Right. So bear in mind that when talking about partnership, in terms of liability, especially, it is not actually to be liable in the partnership. One a person is not actually has a, has to be registered formally under the name of the partners as a partner. Meaning to say, right, you can be liable as a partner even though you are not registered, formally registered under the Partnership Act, especially under the Registration or Registrar of Business Act. Right, so that is the one of the main call that principle in the partnership. So later we will discuss what are those situation whereby a person can still be liable as a partner even though he or she is not registered under the registrations, or business registrations. Okay, before that, what we have to know, what is partnership first. Okay, the definition of partnership is elucidated in under section 3, right? It says that partnership is the relation which subsists between persons carry on business in common with the view of profit. And the exclusions of meaning of partnership are defined under section 3.2. Okay, which is there are 3 exemptions on that. One is companies incorporated under the Companies Act. Number 2, cooperative societies, and the third one is formed or incorporated by or in pursuance of any other law. Right. So basically, one is we have to know what are the elements of the partnerships. First is a business. Okay. To be recognized as a partner in a big business, in the partnerships, there must be a business, right? It cannot be a kind of other partnership which is not the purpose is not a business. So the element of business must be present, for example, to sell goods or provide services. Right, so when talking, as you know, when talking about business, they always look for the commercial methods, activities. So number 2, carried on in common. Carried on in common means that the business must be run by minimum 2 or more partners on behalf of them. Eh? So that is what is in common mean. It cannot be sole proprietorship. Eh? You cannot say that sole proprietorship is also a partnership. No. Eh? So in terms of partnerships, there must be at least two parties or more that run the business. That run the business. So in common also means that they are actually in common in the objective. Eh? Meaning to say, for example, if two persons make a business, for example, running a second-hand car, for example, so they are also, that means they are in common in terms of the objective of the business are running the selling a car, second-hand car. So that is what we call in common in term, apart from the numbers of the partnerships. So number three, with a view of profit. Okay. So there are some institutions or organizations that being formed which is not with view of profit. They are making business, but they are not actually the objective is not actually to make a profit, right? For instance, NGOs that non-governmental organizations, right, or the associations. So they are actually the they are making business. Sometimes they are making business, but they don't pay they don't put the first priority of profit as to make a profit. They don't put profit as the priority, right? So so this is not business. But in term definition of partnership is very clear. There must be a business, and that business is run by more than two in common. And number three, and business must also, they must make a business in a view of making a profit. So that is three elements of partnership. So in other words, in order for a person's for a person to be recognized as one of the partners in the partnership, so the three elements must be fulfilled. If three elements are fulfilled, then he or she can be recognized as a partner. So in these three, it doesn't require that a person or a partner to be registered formally. To be registered formally. But when you, of course, when you say that if the partners are registered formally as a partners, then it's very clear cut lah. But as far as the law is concerned, even though you are not formally registered as a partner, you can still be regarded or considered as a partner, provided that you can prove that the three elements of partnership under the partnership. Okay. So we have a case here, Gulazam versus Nur Zaman and Sobats. So this very old case, not so old lah, 1957. Right? So in this case, the plaintiff claimed that defendant, who were cattle dealers, had made arrangement to form a partnership with him to purchase, keep and sell cattle based on the condition that the plaintiff was to provide capital for the purchase of the cattle, and the defendant were to go after the cattle and sell them, with the profit to be divided equally. So, but after a while, the defendant actually broke the promise to render the account to the plaintiff, and also the defendant failed to pay the share of the profit to the plaintiff. So in this case, the plaintiff sued the defendant, but the defendant defense was that the partnership never existed, on the ground that that the partner had not been registered under Section 8 of the Registration and Licensing of Business Ordinance 1953. So at that time, the Partnership Act was not gazetted yet. Was not gazetted yet. What we had at that time in 1957 is Registration and Licensing of Business Ordinance 1953. Okay. The issue in this case is that whether a partnership existed between the plaintiff and defendant. The court held that the partnership existed between the parties. So the principle of this case is that even though that the plaintiff is not formally registered under the Registration and Licensing of Business Ordinance 1953, he is still considered as a partner. So that is the ratio decidendi of the case. The ratio decidendi. If you still remember the term ratio decidendi. Okay. So the principle of the case is that partnership existed between parties, and Section 8 of the ordinance didn't affect the right of the partner of one partner in a firm which had failed to comply with the ordinance to bring an action against his co-partners. So the claim allowed in this case, meaning to say the plaintiff won the case. Right. So another case is Ratna Amal and another versus Tan Chow Su in 1964. So the fact of the case is that the parties entered into agreement to form a syndicate for the purpose of selling condensed milk. The word partnership was not used in the agreement, so instead the word syndicate was used. So again, in this case, it's clear that there was an agreement between the parties in this case, right? So the only thing is that they use the word indicate rather than the word partnership. Okay, so even the word syndicate in this case, the court held that the fact that the case of reconciliation in the parties had the business character of the partnership, therefore notwithstanding the avoided reference in the partnership agreement and the use of the word syndicate, the agreement arrived at was in fact a partnership. So the court actually doesn't much care about whether that the partners are registered formally, even though they use the different term. Instead of partnership, they use the word syndicate. But the objective and the requirements under Section 3 definition of partnership exists, then the court recognize the partnerships. Okay, so that is the principle in the case. So in other words, in these two cases, Golazam and Ratna Amal, right? What matters in the eye of the court is not actually on the registrations of the partners or the partnerships, but rather whether the partners actually fulfill the elements under Section 3 of the partnership. Okay, so that is the main principle of these two cases, right? Okay, in terms of the operations, right? In terms of the operations, of course, when talking about partnerships, we use the word firm, or enterprise, So in the Malaysian context, they use the word enterprise. And bear in mind, if you want to register partnership, in case that you want to register partnership, you have to go to the SSM, if you know, Suruhanjaya Syarikat Malaysia, under the Registration of Business Act 1956. And again, the legal effect of for partnership, being partners, partnership actually is not a legal person, meaning to say the partners and the firm are the same as one. They are not separated as compared to the company. As you know, the company and the members, they are actually separated. They are legally speaking, they are separated, as if that the company is a artificial persons. So the effect of the of being separations is that when in principle when you want to sue the company, you have to sue the company, not the members, not the shareholders. Okay, but as far as the partnership is concerned, when you want to sue the firm, meaning to say you are also sue the partners. Eh? You are, okay, so that is the difference between company and partnerships. Right. So in terms of duration, there is when the partnership actually doesn't make any arrangement, it doesn't make any agreement. Okay, so the duration of the partnership, if you have an agreement, of course you may determine the partnership, during the period of the partnership. But if you don't have any such agreement, so the duration is when the partners, one of the partners, give the notice of his intention to quit as partner. Okay, so that is the importance of having the agreement in the partnerships. So if I mean to say, if you don't have an agreement, right, partnership agreement, if one of the partners give the notice, to withdraw as a partner, so the whole partnership will be dissolved, right? But if you have the agreement saying that even though there is we call it even though there is a partner withdraws as in the partnerships, so no such thing that the partnership will be dissolved, then the partnership still can still carries on the business. So that is the why the agreement is important. Okay. Okay, we move on to the other subsection, which is also very important: relations of partners and outsiders. So in other words, this is a discussion about the liabilities of the partners. The liabilities of partners. Okay, the one of the main provision in the Partnership Act is under the Section 7. Under the Section 7. So these sections, I would say that this section is the main one of the main provisions in terms of the liabilities. It says that every partner is the agent of the firm, of his partners for the purpose of business partnership, and the act of every partner who doesn't any act for carry on in the usual way of business or become carry on by the firm or he is a member of mine and his partner, unless partners acting has no authority for the firm in a particular matter, and the person with whom he is dealing either knows he has no authority or doesn't know or believe him to be a partner. Okay, so there are two uh, important limbs in this provision. One, the general statement, which says that every partner is the agent of the firm. Okay, meaning to say every action or conduct by a partner can bind the other partners. Okay, so okay, uh, so that is the effect of the one general principle of this. So as long as it is done in the usual way of business, or kind of carry on the firm. So meaning to say, generally, if a partner, for example, makes uh, a loan, for example, so the other partners are also liable, provided that loan must be related to the business that they are in. So that is meant by usual way of business. Usual way of business. So we need to say in usual way of business, making a loan is something like it is a it is common. It is common for a business to make a loan, right? So so that is meant by usual way of business. Okay, coming to the second limb, right? Coming to the second limb, unless the partner, so I think has no authority. So this is the assumption of the liability. So one, if unless that partner has no authority to act for the firm, then the other partners are not liable. The other partner not liable. No authority to act for the firm means to say, for instance, the that person is no longer a partner. So meaning to say he has no authority. Or secondly, it might be they have an agreement which give the authority to make a loan, for instance, up to certain amount, and that the partner has exceeded the authority, beyond, meaning to say he has made beyond the amount, authorized amount. So that is, we say, has no authority. And person with whom he's dealing either knows he has no authority or doesn't know or believe him to be a partner. So in terms of the third party which deal with the partner, right? It is immaterial whether he knows or doesn't know that he is a partner actually. Okay, because most of the time when you in practice, when you have a business, especially when you have a business, you carry the name of the partnerships. If you, for example, you make a loan, of course, uh, you just if it is a personal loan, right? By rights, you don't carry any uh, business, name of business. But if you carry the name of business, right? The third party, for instance, the bank, would require the other partners uh, to be at least another partner lah. For example, if you have five, don't at least two or three partners must consent on that particular transactions. So it is not actually there is no issue of whether the bank or the third party are not aware. The third party is not aware about the transactions. And sometimes they are not concerned whether you have authority, to certain amount of the loan. Okay, so this what happened in the restaurant riskin, and as Asia Commercial Finance. So what happened in this case is that you can read. You can read. I will upload in the author. Okay. So other provisions also important in this section 9, regarding the partners that cannot guarantee the debts of the partnership firm of the firm lah. So it says that when one partner pledges the credit of the firm for the purpose of apparently not connected with the firm ordinary course of business, the firm is not bound. Eh? So this is when the credit made by one of the partners is only connected with his personal purpose, not the firm ordinary course of business, not the firm ordinary course of business. For example, like if you as a partner, right, you make a credit or personal loan, so the other firm are not actually bound to pay your your loan, so that is the principle under section 9. Number 3 is tort under the law of tort, tortious act or wrong, so this is provided under section 12. As far as the tort is concerned, the when one partner, right, commits tortious wrongdoing, a civil wrong, right, in the course of business, in the course of business, so the other partners are also liable. Okay, so this is we have a case here, Biff and Fladiate, 1891. So the explanation of section 12 also means that, for instance, that if a partner, for instance, made an accident that caused injury to the third party, so during performing the duties as a partner, so that is the other partners are also liable, so because we consider as accident as a negligence, okay, so that is one of the example of the tort. Number 4 is misapplication of money, so money or property, there are two things, money or property. So for this means that if a third party put his money or property into the custody of the firm, if one of the partners misapply that money or property, the other are also liable, so simple principle, but this must be a proof that the partner misapply the money or property in the ordinary course of business, or there are two, the firm received the money or property, or one of the partners misapply the money and property, or during there is no such a present of the ordinary course of business, we need to say respective whether it is ordinary course of business or not, the other partners are liable in terms of misapplication of money, property. Okay, so there are two sections and provisions made. One is misapplication under section 13, and another one is misappropriation, section 15 of the they are the same, they are the same. So oh yeah.